Welcome. Welcome to this new episode of the Dynamic Antitrust series. Today, we're going to talk about the Digital Market Act, this new piece of EU regulations. The DMA will have a significant impact on the operation of digital platforms. It requires large online platforms who act as a so-called gatekeepers in the digital markets to comply with wide-ranging obligations. Who are those gatekeepers and which obligations and prohibitions does the DMA impose on them? Why and for which consumer benefits? And what are the intended consequences of the DMA? A lot has been said about the DMA, and many, including myself, raised concerns about the potential unintended consequences of the DMA. This European regulation adopts a very precautionary approach to highly dynamic markets and risks stifling innovations and perhaps harming consumers. Others have embraced the DMA as a boon for regulating the digital economy. Anyway, so today's discussion will focus on the implementation side of the DMA. The official legal text of the DMA will be published in the EU's official journal in autumn this year. It will enter into force 20 days after publications and will become applicable 6 months later, most likely in March or April 2023. So today we launched a report of the Schumpeter project on competition policy at ITIF that just released. This report is titled The Digital Market Act, a Triumph of Regulation over Innovation. The report demonstrates that the Digital Market Act presents three fundamental challenges as it nears adoption. First, it will increase regulatory fragmentation. The DMA is supposed to avoid regulatory fragmentations between member states. The DMA may, however, facilitate further regulatory fragmentation. Second, it has disproportionate blanket obligations and prohibitions, which will be economically detrimental and are legally controversial. So there may not be any efficiency defense, but rather an efficiency offense. Pro-competitive behaviors by firms may not have an effect on justifying their conduct. And third, and that's perhaps the point of today's discussion, the DMA would be very difficult to implement, as some of its provisions may conflict with other European regulations. So even if gatekeepers are very willing to engage in a so-called regulatory dialogue with the European Commission, it may be very hard to implement the DMA. And that's perhaps why the European Commission has recently opened an office in San Francisco Bay Area to engage in this regulatory dialogue with other gatekeepers and see how to implement the DMA, which has more vague principles rather than these clear rules of the road that we could have expected. So in order to discuss all these very important regulatory challenges, we have a stellar line of speakers today with us. So I'm delighted to have first with us Lea Zuberg. Lea is a policy officer at the European Commission. We also have Denis Sparas. Denis is a legal and policy officer also at the European Commission. We have Andreas Todt, who is chairman and chairman of the Competition Council, vice president of the Hungarian Competition Authority, and associate professor of the Károlyi University of Budapest. We have Professor Renato Nazzini, who is a professor of law at King's College London. And last but not least, we have Giuseppe Colangelo, who's doing a lot of things, and among which is associate professor at the University of Basilicata, and fellow, I think, at Stanford University. So thank you all for joining us on this very important discussion on the implementation of the DMA. Perhaps I may start with Denis on explaining the implementation aspect and the regulatory challenges that I just briefly mentioned on as respect to the DMA. Denis?
Thank you, Aurelien, and of course, thank you for the invitation and giving us the opportunity to present the DMA. I mean, as you have heard from the presentation of Aurelien, we will be two from the European Commission talking a little bit about the DMA as introductory remarks, and then of course, looking forward to the panel discussions and Q&As. So just I will try to focus on a couple of aspects which have also come across in the report that Aurelien was referring to, and then my colleague Leah will focus on some questions around the compliance enforcement and also relationship with competition rules. So just very briefly, because it's quite often the question arises, what is the DMA and what kind of the tool the DMA is? And I think the first point that is very important to clarify and to flag in this context is that the DMA is a harmonization instrument. So, it's first point in that context that is important to keep in mind is that it's kind of continuation of the policy work that has started quite some time ago. As you will know, the European Commission has done a number of policy and regulatory initiatives in the area of online platforms and digital services more generally. So when we think about, the relationship between platforms more generally and their users, in particular business users, we can identify as kind of a baseline scenario the platform to business regulation, which has been adopted not long time ago and also came into force in 2019. The DMA proposal in that context goes one step forward in providing for harmonizing instrument to ensure, again, the same type of objective, effective functioning of internal markets, but in those markets in the digital sector where gatekeepers are present and where the aim is to ensure contestability and fairness in the commercial relationship. So in that sense, it's an instrument which is based on Article 114, and it's not a competition law tool. And I think that's very important to clarify, because very often what we hear in a number of papers, a number of conferences, that the DMA is competition law tool. I think that's important to clarify that it's not the case, that it's really a regulatory tool. Now, on the point that Aurelien was referring to, and the risk and the challenges around fragmentation, as said, DMA is harmonization tool. That means that there should not be and there cannot be any further obligations imposed on gatekeepers for the objectives and the purpose which the DMA is pursuing, which is ensuring contestable and fair markets in the internal market. In that context, it's also, again, important to flag that DMA is not replacing, but it's complementary to rules which are pursuing any other legitimate interest. And there will be rules which will apply to the market operators that are covered by the DMA, and these rules can be in the area of consumer protection, unfair trading practices, you name it. And then the other set of rules which DMA is not replacing or in any way changing are EU competition rules and, of course, national competition rules. Now, the point of fragmentation and the fact that the DMA, that there is a risk that the DMA would lead to further fragmentation is in a way addressed through these two harmonization objectives. And the DMA is actually addressing some of the examples of fragmentation that we have observed so far. For example, you had national laws in a number of member states which were dealing with the question of parity clauses in different sectors, or we have observed some national rules concerning, digital payment services. So in that sense, the DMA does provide for a framework which aims to ensure, harmonization in the specific area. So just very quickly, what kind of a tool is DMA beyond the fact that, we are talking about internal market rules? One important aspect and the relevant feature of relevant features of the DMA is in relation to designation. So when we talk about the designation in the context of the DMA, we are talking about, a process which is, upfront and decoupled from the enforcement of obligations and prohibitions. What does that mean? Based on very clear criteria which are laid down in the DMA, and which are based on substantive assessment which has been done at the stage of the impact assessment. The idea is that any undertaking providing core platform services that meets certain quantitative thresholds is upfront designated as a gatekeeper, with, of course, certain, let's call them, exceptions to this, like any of these market operators could come with the rebuttal, which would need to meet certain legal standard. And in certain cases, where this rebuttal would put manifestly into question the rebuttable presumption, the Commission would have to conduct a market investigation. What is important to keep in mind is that the Commission has no discretion in relation to this quantitative designation. So once notification is received, it has to be processed, and there is very clear procedure and process which has been established in the DMA, in particular in Article 3. And the third point, which it's important to keep in mind in this context, is it's deadline-driven procedure, contrary to some other areas of law, which are often also in the paper that Aurélien was referring to, where it is pointed out that it takes quite a lot of time. The DMA procedure and process is driven by deadlines, which are very strictly set. So, for example, the Commission has to take a decision on the quantitative designation within 45 working days. Should there be a market investigation due to successful rebuttal, there would be a requirement to finish the market investigation within 5 months, or in case of classical qualitative designation, there would be a period of 12 months. So this is, the relevant features more at the level of designation, so more the market operators which are being addressed by the DMA. The other important aspects and what's new about the DMA is the substantive framework. So we are talking about specific and directly applicable proportionate obligations, which are self-executed and which are aimed at ensuring contestability and fairness in the market. And again, there were, if you have a look at the impact assessment, which is kind of accompanying the proposal, all the practices which have been identified were following certain principles which are identified. There should be sufficient experience with the harmful effects of these practices. Such experience should point to the egregious nature of these practices. To the extent possible, all these obligations should be directly applicable, and the unfair practices that are being addressed by the obligations and prohibition should be identified in a clear and unambiguous manner. So, there were certain principles which have been guiding the Commission in setting which the obligations and prohibitions should be set out in the DMA. An important feature of the DMA is also that, for example, there is no commitment in the non-compliance proceedings. The reason for this is that we are in a framework which provides for clearly defined obligations, and because of that, the co-legislators felt that it should not be allowed in such circumstances to come up with the commitments to address the non-compliance. This may be different in case of structural non-compliance, which means, where specific forms of non-compliance are engaged in on a number of occasions, and where potentially different, additional remedies may be required. And there, the co-legislators felt that indeed, it is possible to come up with additional remedies, including through the commitment stage. And these could be, of course, of behavioral and structural nature, including temporary restrictions of acquisition activities. I would maybe stop here, so that we would also have sufficient time for the discussion, and looking forward to that.
Thank you so much, Dennis. That laid down the stage very, very well. I may move to perhaps Renato for his view on the DMA generally, and perhaps the implementation side more specifically. Renato?
Thank you very much, Aurélien, and thank you very much, Dennis, for his introduction. So the DMA is basically about to become law, so the question is the implementation, really, regardless of the views that one had on whether that was a good idea or not in the first place. So I'd like to make really perhaps 2 points there in the interest of time. And one, really picking up on something that Dennis said. So is the DMA competition law or not. And why is that important in relation to implementation? Because, of course, you can have an intervention by the Commission under the DMA and then application of national competition law, for example, by national competition authorities. So the DMA ostensibly states that it is not competition law, right? But is it just enough to make a declaration this is not competition law for something not to be competition law? Or does one look at the substance of it for the purpose of legal principles such as the nebis in idem principle, for example? And, you know, if we say that the objective of the DMA is indeed to ensure that markets are open and contestable and fair, I mean, these are really concepts, you know, contestable markets are competitive markets. I mean, that's an element and part and parcel of competition law. Indeed, if a dominant company, by its conduct, makes markets less contestable because, for example, engages in behavior that makes market access more difficult or impossible for competitors, that's obviously a competition infringement. And the concept of fairness is very much embedded in Articles 101 and 102, whatever it means, but these provisions really use the word fair. So, and the second point, I mean, to make here very briefly, is if you look at the list of prohibition in the DMA, where very many of them are either ongoing or decided competition cases. I mean, the most egregious prohibition is, of course, the prohibition of self-preferencing or favoring, which is, of course, the Google shopping case. So that does mean, I think, that when a DMA, if the DMA is really a harmonization instrument, then when one of those obligations applies, and I would say even more so when there has been an intervention by the Commission in terms of enforcement, then the application of national competition law to that same practice or conduct on substantially the same facts is prohibited under EU law, and should be prohibited as a matter of basic justice, I would say. The second thing about implementation, I mean, a lot has been said about, and is picked up in the excellent report that Aurélien has produced, is that a lot has been said about the fact that there is no efficiency defense, or in a way or another, there were hundreds of ways of doing it, but the DMA has not taken into account and does not allow any room for arguments or defenses that the conduct is indeed on balance, not detrimental, is efficient, it brings about substantial innovation, and so on and so forth. And the question is that the end of the matter? And I do think that it is not necessarily the end of the matter. Now, the prohibition of the CMA, of the DMA, are indeed blanket prohibitions, is regulatory law in the intention of the Commission, but still there are a lot of words, you know, in those prohibitions, and words, as we know as lawyers, are open to interpretation. So that's the first way in which I guess the European courts and the Commission itself, perhaps in the first place, can interpret those prohibitions in a more reasonable way. A reasonable interpretation under the principle of proportionality is, I would say, mandated, required under EU law. And secondly, an efficiency defense, quote unquote, because I'm not thinking of a specific wording or a specific defense, but building in some element for an efficiency justification is not necessarily ruled out. It is true that there is no room for that in the DMA, but there was no room for the mandatory requirements exception under the Cassis de Dijon case law, and still the Court of Justice felt able to read an exception into a treaty rule, which did not on its face allow for that exception. This is not even a regulation; it's a treaty rule, and on free movement of goods, of course. And if you think about competition law, of course, there is no efficiency defense under Article 102, but now we know under the case law of the court that there is. And I don't know, Aurélien, if I can make a third point, because I know we have very short time. Otherwise, I shut up.
You can.
Okay. The third point now is kind of more, it's a slightly broader point, which is, of course, there were different ways of doing it. I'm certainly not one of those who think that there are absolutely no issues with these digital tech giants and everything is fine and nothing should be done ever. Of course, anybody can, especially companies with substantial market powers, can of course engage in conduct which is detrimental to social welfare. But there were different ways of doing that, and the thing I would point out is that the UK, which is of course now no longer in the European Union, has gone a different way, will go a different way. We don't really still have legislation. There have been, as you know, in the past few months, quite a few issues to deal with over here. But definitely what the UK digital strategy that now has been endorsed by the government and that will be a legislation in due course tries to achieve the same objectives, but in a different way. First of all, the tool will be a competition tool. So I would say that's the right approach. For example, the designation of the company with the undertaking with strategic market status will be based on the market power analysis. So that's the first important difference. The second important difference is that it would be a tailor-made approach. So there will be codes of conduct applicable to individual, what under EU law would say gatekeepers. So it's a tailor-made approach, and as a tailor-made approach is clearly superior, more expensive, obviously. I understand why the European Commission didn't want to go that route or across the entire Europe. Perhaps it was more suitable for one nation jurisdiction like the United Kingdom. But so there will be a code of conduct for gatekeeper 1, code of conduct for gatekeeper number 2, modeled therefore on the business model actually and on the actual problems that there are. And then also there will be remedies, obviously, or pro-competitive interventions, but these will also be tailor-made to a specifically identified problem. So now that the UK is outside the European Union, perhaps once also the UK regime will be up and running, we can look at an interesting natural experiment, and so which system works better. I'm Italian and I'm also British, so I cannot really take sides. I'll just sit back and observe what happens. Thank you very much.
Thank you so much, Renato. Leah, I take this time just to also thank so much Leah and Dennis from the European Commission to engage with scholars and academics and think tanks. I think that's great, and so I just wanted to thank you because you may take some, I wouldn't say some concerns or criticisms, but I think it's great to have open discussions and with its desire to engage in discussion and to improve the DMA, or to improve at least the implementation of the DMA. So thank you so much for your contribution and for being here. Leah, do you want to?
Yes, good afternoon, everyone, and thank you, Aurelian. I think we are happy to be here and listen to all the participants and criticism, of course. I mean, the text has now been adopted, as you know. It is what it is, as some would say. So, but I completely agree with you. I think we need to make the best out of it. Although sometimes I have a little bit the impression that there is, it seems that we as the Commission have a lot of discretion when it comes to the DMA, and I think, you know, maybe in some processes that's true, but in others, for example, as Dennis already mentioned, when it comes to the designation of the gatekeeping companies, I mean, we also need to stick to the letter of the law, and we also don't have so much margin of maneuver to now say, you meet the numbers, but maybe I will not designate you. So just to have that in mind as well. I think I will also do a couple of points on compliance and enforcement. So just to say that what we see as especially when you compare it to competition law enforcement, a shift in the DMA is clearly that the responsibility for the compliance and the burden to demonstrate effective compliance is on gatekeepers. So in this respect, we have this self-reporting obligation where the companies will need to show to us how they comply with each and every obligation, what are the changes that they have undertaken in this respect. Perhaps some companies will not have to make many changes because already they don't engage in some of these practices. But that will definitely be the first thing that we will look into once the kind of the deadline passes. I think it's also fair to say that, I mean, of course, it's new for everyone. It's new for us. It's new for the companies. I can say that we will be more easily convinced, for example, if the companies tell us that they have discussed these compliance solutions also with their business users and with end users. So I think we also want to make this process as transparent as possible, and I think that will be definitely one of the things that we will very much value. We often get a lot of questions about this regulatory dialogue tool that the DMA has envisaged in Article 8, which is a mechanism through which we can specify some of the obligations. So again, it's not to say that the obligations would not apply as such, but it's just a tool to specify them. But I think, looking at the timelines in the DMA, I think this is something that we will try to do as early as possible. And I think we have always been saying that, our doors are open, and companies who already now want to think that they could be designated as gatekeepers and want to already now start thinking about compliance solutions, we are very happy to engage with them in this respect. As early as possible. Maybe just to mention, and it was, I mean, Renato touched upon the efficiency defense. What we have in the DMA very clearly set out are two quite exceptional cases when the gatekeepers would not need to comply with certain obligations. So we have this suspension and exemption. One talks about really putting the economic viability of the gatekeeper in question due to some extraordinary circumstances that the gatekeeper had no control of, and then also for being exempted from certain obligations that can happen on grounds of public health and public security, which I think are concepts well developed in case law. So I would say that we don't see any room for an efficiency defense in the case of competition law. I think that was precisely the goal of the DMA, is to come up with a list of behaviors for which we, in the first place as the Commission, because we put the proposal, but also then the European Parliament and the member states thought that, these practices are clearly unfair. These practices are clearly harmful for the contestability of the market, so that there are no, let's say, trade-offs to take into account. But of course, we're happy to discuss this further. So when it comes to the enforcement structure, so the Commission as the sole enforcer of the DMA, which means that we will be able to take the decisions on the designating the gatekeepers, the decision on opening a non-compliance procedure. But it doesn't mean that we will not rely on the really vast expertise of the national competition authorities and also other authorities. I think the regulation contains a number of provisions on this respect, which really go towards, cooperation in the different areas, and specifically when it comes to competition law, we will be building on the very good cooperation that we already have within the European Competition Network. You also need to note that many of these decisions that the Commission can take are actually implementing acts, which means that the Commission's draft decision needs to be looked at by member states experts in an advisory committee. So the member states will also be involved in this respect. And then we also envisage, we have to set up this high-level group which will bring together representatives of the various regulatory bodies, for example, the European Data Protection Board, BEREC, the telecom regulator, the consumer network, etc., etc. Just also to say, not to take too much of a time, I think we really, when we look at the enforcement, I think we really see that there would be a shift from, let's say, a case-centric approach to ongoing regulatory oversight and dialogue. We also have a provision on compliance officers that need to be appointed within the company. So we really see it as a continuous process, this monitoring process. And even though there are no formal complaints mechanism, because if I remember correctly, the co-legislator didn't want to burden the regulation with embedding some formal complaints mechanism. But as I said already, I think the voices of third parties, of the business users and of end users will really be very important when we will be looking at these compliance solutions. And maybe just to finish off, and then I will just say very briefly, and then we can discuss after on the interaction with antitrust enforcement. We always say that they will continue to coexist. I think, the gatekeepers, it will be a handful of companies, okay, but perhaps with several core platform services. So first of all, there will be other players out there that will need a competition law intervention. Then the services which are listed in the DMA, they are not all services that exist in the digital sector. I mean, you say it yourself. It's a very dynamic environment, and I'm sure that we will have new services coming in very soon. And then also, as I said before, the behaviors that are prohibited or the behaviors that the gatekeepers will need to put into place are only some of those, as you rightly say. I mean, of course, this is all competition law inspired, the list of obligations and prohibitions, but that doesn't mean that the DMA covers all possible behaviors. And precisely as you say, when new behaviors will appear, then indeed competition law will be a more appropriate tool precisely to take into account, okay, these are perhaps the negative sides, these are the positive sides. How does this work out for market and consumers on balance? So perhaps I stop here and we leave the rest for the discussion. Thank you.
Thank you so much, Leah, for this very interesting point. I'm sure we'll come back to many of those later on. Next, Giuseppe, do you want to have your say about the DMA? I know you wrote a lot about it, but on the implementation side?
Thank you very much, Ariane, for inviting me. And let me join you and thank Dennis and Leah for engaging in this discussion. I guess that probably some of the things that we are talking about today probably would be useful to discuss even before the DMA has been approved, because I guess that we share several concerns. I have to admit I'm not a huge supporter of DMA. For several reasons, but even if I look at the main goal that apparently is pursued by the European Commission, I feel that there is a risk that is going to come short in its main goal. I'm referring to the fact that to support the legal basis of DMA, the main goal is the harmonization. Actually, I expect that at the very end of this process, we will have an even more fragmented implementation of DMA antitrust law in EU. I mean, we know that the DMA declared that is different from antitrust law, and I'm not copy and paste what Renato has already said, because I totally agree with him. But it's not just a matter of substance. It's a matter also the way in which we are going to deal with current antitrust law. Because as you already said, DMA, I would say, is an attempt to taking over antitrust law, but is not displacing antitrust law. So if we look at the final outcome, we run the risks to see that the very same undertaking for the very same practice may be judged in different way according to the DMA, according to the implementation of national European antitrust rules, according to German antitrust rules, there is another model, and according to the national antitrust rules on the abuse of economic dependency. So we have different layers that are going to tackle the very same practice and the very same undertaking. And this is not just a matter of double jeopardy, because probably in the last version of the DMA, the commissions maybe succeeded in finding a way to meet the requirement of Biposten or Zucker, but there is a matter of fact that we are going to deal with different kind of implementation of the very same rules. And due to the fact that the DMA apparently took insight from several antitrust cases, and by the way, some of these antitrust cases has been successful, Google Shopping, Google Android. So even the main claim of the DMA, we are unable to tackle this practice because antitrust is unfit. I don't know how much it's going to gain support. And if we look at the national implementation of the rules, I may think to Germany, France, Italy, Amazon logistic case, all the Google case in France, the Facebook case in Germany. But well, they didn't take so much time to end in a decision. So even if we look at Google Shopping as the case that took several years to decide, and so we need a regulatory tool to shorten the enforcement. Well, we do not have just Google Shopping in Europe. But to me, the main problem is that I see concern in terms of fragmentation. Then, when it comes to other concerns, well, Europe, and let's bring just for once UK as a geographical proximity within Europe. Europe developed 3 different models on how to address digital gatekeepers. Renato mentioned the UK one that I strongly support, at least in terms of really regulatory intervention. And the difference between the UK approach and the DMA is pretty significant, because it's not only related to the structure, the fact that we have a code of conduct tailor-made, so and UK is not judging in advance how much are anti-competitive specific practice. And so they are free to evaluate the practice according to the different business model and so the different player. But we have to be honest, the UK is expected to enforce its code of conduct for 3-4 players. The DMA is going to be implemented, I don't know whether the impact assessment is right or wrong, but starting from 10 to 15 players. We know that there are other players that probably are not in the scope of the DMA. But we have to tell you that when it comes to 10, 15 players, and this is not a picture that we are taking right now because it's going to change over time, the possibility that you are going to cover all the antitrust-like enforcing digital market is pretty significant. So we run the risk of overlap. And the overlap is even more apparent if we look at the third model. That is the German one. That is pretty troublesome in terms of implementation of the very same type of rules in EU, because the German one, as we know, implemented a complete competition tool, because it's an update over their national antitrust rules. They are going to tackle the very same practice that had been addressed by the DMA. And we just heard that the economic ministry is proposing an additional reform. So a competition tool for Germany. So in this case, Germany is taking the best of UK, the best of the antitrust rules, and actually it seems to me that in terms of competition law is a sort of German exit, because really we are going to see the very big players that are going to be judged and probably sanctioned early in terms of time when the DMA is going to become effectively law. So my concern is not only about the fact that this is a sort of takeover antitrust disregarded the economic analysis, because at the end of the day, we are lawyers. Lawyers, I guess that will be more than happy about the DMA. And the concern in terms of their professional space is more about the economists, because I don't know what the economy are going to tell us after the DMA. But in terms of lawyers, we will have space to discuss about designation of gatekeepers, how are going to be implemented the prohibition, because again, we know that some of these prohibitions are self-executed, but again, let's be frank, I'm not so sure that they are going to be self-executed, because when you describe very narrowly a practice, there will be a room to say, well, my practice is not necessarily the one that you wrote down in the DMA. I'm just going to leave space to Andres.
Great, thank you so much, Giuseppe, for these excellent points. I think there's a risk indeed that the Germany may have such a very important role in shaping what is pro-competitive or anti-competitive, and we will see, I think, more fragmentations by different national rules. I think that's very likely. Andras, thank you for being with us. What is your take on the DMA? And again, let's focus on compliance and implementation specifically.
Okay, thank you for inviting me. From member states competition authority perspective, I would like to make 3 comments. As Professor Nazzini said, the DMA is not an enforcement, but it is a regulation, which for the majority of the competition agencies is a totally unknown, unfamiliar area. We are enforcement agencies and not regulators. But luckily, the DMA gives very limited powers and tasks to the national competition agencies. If we look at the DMA, we have procedural assistance, receiving and forwarding complaints, task, monitoring non-compliance on voluntary basis. So I don't expect that in case of the majority of the member states competition authorities, cooperation under the DMA would result in a significant additional burden. Procedural assistance required by the DMA seem to be very identical to those already well known under 2003. I don't expect that in case of the majority of the member states would be affected deeply by this procedural cooperation, taking into account location of the gatekeepers, head offices, where the evidences can be found with good chance. So therefore, unlike the ECM Plus directive, DMA doesn't actually require member states to give national agencies sufficient resources for enforcement. So therefore, I think that, and this is my second concern, that it's highly questionable whether the national competition authorities we have incentive to dedicate time and resources in monitoring a regulation that actually they will not enforce. So actually, the national competition authorities would act in a shadow without any public recognition, cost without any benefits. And my third concern is that the Commission can rely on resources and expertise in only very few NCAs, to be honest. So if we look at the national competition authorities who took the lead on the digital field in the past few years, probably France, Germany, Italy, probably the Dutch competition authorities, who can say that they are very well expertised on this field. In Hungary, we are very active on consumer protection side, where we are very expertised, and which gives us the possibility to intervene into the digital market. Due to the fact that under the GDPR, the National Data Protection Agency is unable to intervene, the consumer protection gives us a very good chance to replace the National Data Protection Agency, actually. So we take some role from data protection side under the consumer protection. But as Giuseppe said, we are very curious about the prosperity of the German legislation. What is the prospect of the German-like regulation on this field in the future? It's highly questionable for me in the light of the DME, according to which it is permitted for the national competition laws to complement the DME, which prohibiting other forms of unilateral conduct insofar as they are applied to undertaking other than the gatekeepers amount to additional obligations. So I don't know. I know that in the Eastern Bloc of the EU, considering the countries of the Eastern Bloc considering the German-like regulation in their national law. But in light of the DMA, I don't know what will be the prospect of the German-like regulation. I think the national legislators are curious about the future of the German regulation, and in the light of the future of the German law, will the Eastern Bloc's regulators or decision makers decide about the plan, any plan to introduce DMA-like regulation in the national law. Right. That's it. Thank you.
Thank you so much, Andreas, for those points and those concerns. So let's perhaps to come back into for Dennis and Leah to react on everything they've heard. But I may have perhaps one or 2 points that I would love to have their insight. We talked about a lot about regulatory dialogue, and that's great because there's there's some benefits about regulatory dialogues between the European Commission and those gatekeepers. But each time I hear regulatory dialogue, I sometimes fear regulatory capture. And are you concerned about the fact that the DMA wants to lower the entrenchment effect of some of the gatekeepers, but are you concerned that the DMA may even further the entrenchment by some regulatory capture where we end up having less innovation, but more entrenchment as well? So that's my point. Like, what about the aspect of regulatory capture? Another, and that's what Giuseppe referred to, is like, what's the probability for like additional national competition regulations on the basis of Germany? I mean, the DMA, the European Commission, could have almost prohibited member states to have more national regulations, right? I understand that's what Martha Vestager, when she introduced the DMA in December 2020, said. So like, there won't be national regulations about it. And 2 months after, the German competition rules were adopted. So to what extent, in order to ensure non-fragmentation, to what extent there could not have been no additional national competition regulation on this aspect? And final point for us, with what Andreas touched upon, what's the complementarity about the DMA and GDPR? And there's a lot of concerns about this very intractable compliance. So if you want to react to these 3 points and perhaps of course, but everything that you've heard, just pick one of those points.
Okay, thanks, Aurélien, and most of all, thanks to everyone for very interesting and valuable points. I mean, I very much take the point of Giuseppe, that many of these points which have been raised should have been raised and discussed at the time, when the DMA was I don't know, proposed and discussed. And I would just like to maybe comment on that. Many of these points, if not all, were actually taken up and discussed at the time, and the number of solutions which have, been introduced in the final text of the DMA actually reflect number of concerns that have been raised in one way or another, but they do address. So, for example, the report that has been prepared on number of occasions actually addresses issues which are not necessarily the final solutions. So, maybe some of the points that have been raised as concerns have already been in one way or another addressed. Now, maybe just in the interest of time to focus on the questions of Aurélien, and then, if we want to come back to any of other points, happy to do so. So on the point of regulatory capture, I mean, I would understand your question as, asking, because there is probably a limited number of gatekeepers today, so the companies that meet the quantitative thresholds or that will be designated through a qualitative designation, that may lead to regulatory capture because it's a low number of such market operators, or expected low number of such market operators. I think from our perspective, we don't see a risk of such a regulatory capture. We are not concerned that the the implementation and enforcement of the DMA would lead to further entrenchment of this. I mean, you will appreciate that the DMA, as such, with the rules it lays down, aims to ensure that the conditions on the market are fair and allow for contestability. So allow other market operators that may already be there or that may be thinking to enter specific markets, to enter and to provide innovative services, also based on addressing some of the unfair practices that have been previously shown to limit that ability of the market operator. So we don't see this fear of a regulatory capture, and we believe that the rules as finally adopted by agreed to by the co-legislators should and will not lead to further entrenchment. Now, on your point on this additional rules and further fragmentation, and this has come across quite strongly, I think it's very important, and this was very important point also for both co-legislators, to again remind ourselves that because of the concerns which have been raised and discussed on this specific issue, we have Article 1.5, we have Article 1.6, which try to deal with the relationship between, on one side the DMA, and on the other side either the national laws which pursue different policy objectives, or national competition rules, both on the antitrust side and the merger side. And again, to provide guidance to be able to assess which those competition rules are, there is a recital which tries to identify what should be understood as competition rules. But in terms of regulatory fragmentation, I think it's important that at the level of the regulation itself, we have these provisions, and it's very clear if the member states would legislate in the area where they would pursue objectives based on the same objectives as the DMA, which is ensuring fairness and contestability, this is something that the DMA would preclude. Of course, it would not preclude, and that's clarified in the DMA itself, if there would be certain additional obligations which would be imposed on gatekeepers. And then on the enforcement side of the concern of regulatory fragmentation, we should not forget about the mechanism of cooperation and coordination, which is envisaged in Article 38(2), paragraph 2 and 3, which is talking about the procedure where national competition authority, when applying rules in the context of this Article 1.6, so national competition rules, should inform the Commission about such action, both at the level of opening, but also at the level of taking a final decision. And such cooperation and coordination mechanism is aimed to ensure that there are no, conflicting decisions taken. I mean, you will also appreciate, and that's the final point I would like to make, and then Leah may take the last question. There is a possibility for the Commission to also adopt implementing rules in this context, to further, lay down this mechanism of cooperation and coordination, But I mean, again, this is something that is currently being assessed because, you know, the DMA itself already very clearly sets out what that mechanism of cooperation should look like, because it very clearly refers to the European Competition Network. Maybe I would stop here and maybe Leah takes the point on GDPR.
Yes, no, sure. I think, and these are all valid points, and we have to see how it will work in practice. But I think, you know, the purpose again of the DMA, when I think about you know, actions by national competition authorities, I mean, we also need to see what would be the incentive, you know, what would be the incentive to follow a behavior which, let's say, is already covered by the DMA and which the gatekeeper is complying with or not complying with, and the Commission already started proceedings in this respect. And I think maybe also an important point to raise is that, I mean, I never did competition law enforcement, so I don't want to say anything wrong, but normally it's for past behaviors, right? So it's an ex post intervention. So you are, let's say, the punishment is for the deeds of the past, whereas here now, and that's why we are saying that the shift is to ex ante things, to even prohibit things before maybe they are even taking place. That's why I'm saying maybe some companies will not have to make many changes. But maybe just to come to the last question on the DMA and GDPR, and I can just echo already what Dennis said about the need for cooperation. I mean, I think we are aware that especially in some provisions, very concretely Article 5A, very much relies, for example, on the notion of consent from the GDPR, and I think it's really in no one's interest that now we have multiple interpretations, conflicting interpretations of this. So we hope that through this high-level group, which was set up, which will be set up precisely for these purposes, that we can then also discuss some very concrete issues in this respect. Not to say that this is something that can be done in a day, not to say that this is not complex, but we are just at the beginning of the process, and we think, you know, that the DMA at least gives us the good tools to then come to uniform solutions.
Great, thank you so much. So it will take place more in the high-level group. I understand. So that's these are great. We're running out of time. It's a fascinating discussion. I think it will last for 3 hours, but we're going to try to keep it for 1 hour only. So perhaps just 1 minute, Giuseppe, final statement, Giuseppe, Renato, Andreas, and then we can close. It has been fascinating and we learned a lot. Giuseppe, 1 minute, final thought.
Well, I guess that will be challenging time. It would be interesting to see, at least in Europe, probably also in US, how regulation and antitrust will live together. And again, as competition lawyer, I'm pretty happy to be part of this debate.
Great, thank you. Renato?
I would just say that one thing that perhaps we haven't touched upon is the global and international dimension. I mean, Giuseppe just mentioned the United States, but you know, of course, all major economies and pretty much all countries actually are adopting or have adopted rules in this area, whether it's competition law, whether it's regulation. I mean, I have been following closely South Korea and Japan, but really it's a little bit of everywhere, and one has to also bear that in mind. So there has to be also, I think, some hopefully international cooperation. I mean, these businesses are global, and one of the reasons they are successful, and hence they become gatekeepers in the eyes of the Commission, obviously, is because there are huge benefits in realizing these scale economies across markets. And you know, I think even the European Commission obviously does recognize that there are also benefits in these innovative tech companies and in these economies of scale. So again, I think in the next few years, one of the challenges of DMA is, as Leah said, what it is. But I think we will have to look at the international dimension as well.
Thank you very much. And Andreas, to close up the whole discussions.
Yeah, I expect that the litigation will be in the focus of the implementation in the DME in the near future, because the DME actually affects one of the most core issue of the digital economy, which is the innovation. And for me, it seems that the DME clearly promotes decentralized instead of centralized innovation, which is a very, very crucial point. It is a decision made by the European regulator. So therefore, actually, EU regulator has decided not to favor competition between large ecosystems, but broken up them and make them contestable. So therefore, I expect that the litigation will become a focus of the implementation of the DME in the future. Thank you.
All right. Thank you so much for these fascinating discussions. Let me thank very warmly again Denis and Leah for taking all these questions and engaging in that discussion, which has been very enlightening and just shed light on many aspects of the DMA. I'm sure the audience had improved understanding of what is the DMA and also what lies ahead of the DMA. So thank you all, and I'm sure the discussion is only starting as we just hit into. Thank you all. Bye.